Welcome to This Explainer. Today, we're unpacking a fascinating and honestly highly relatable true legal drama about a homeowners association dispute that actually escalated all the way to an administrative judge. If you've ever lived in a condo, a townhome, or any community with shared spaces, you know that property lines and HOA rules can sometimes feel like an absolute minefield. Well, we're going to look at a real-world case that perfectly illustrates just how complicated these neighborly disagreements can get. We'll break it all down step by step using the official legal documents. Okay, let's dive right into this. So how much trouble can one single concrete slab really cause? Well, as it turns out, an incredible amount. We're about to look directly at the official 2014 Office of Administrative Hearings decision in the case of Krystine P strike versus the Las Torres Homeowners Association. This isn't just about a piece of pavement, It's a deep dive into property rights, the strict limits of HOA authority, and the unforgiving timelines of the law. But to really understand how we got here, we have to start right at the scene of the crime. Section 1. The crime scene and background. Okay, before we get into the legal crossfire, let's set the scene and understand the physical space where all this drama unfolded. Our setting is Las Torres, a homeowners association located in the picturesque town of Carefree, Arizona. The basic geography of the whole conflict centers entirely around the space between two specific adjacent residences, Unit 603 and Unit 604. Now, in a lot of condominium complexes, the area right outside your door might feel like it's yours, but legally, it's often designated as a common area. In this specific case, there was a concrete slab sitting right in the common area that joined the existing patios of these two units, essentially creating one long stretch between them. And this exact quote really illustrates the high stakes of our dispute. This is straight from the petition filed by Krystine Strike, the owner of Unit 603. She explicitly demanded, "I want the common area restored to its unaltered state." She wasn't looking for an apology, and she certainly wasn't asking for a compromise. She literally wanted this concrete ripped right out of the ground. She alleged her neighbor was treating a shared space as a private patio, encroaching on the common area and fundamentally violating her privacy rights. But here's where things get super interesting, because the timeline is absolutely critical to understanding the case. Consider the massive gap in time here. Ms. Strike bought Unit 603 in 2007, and she filed her legal petition in late 2013. However, that concrete slab she wanted removed, it was actually poured way back in 1998 by the people who previously owned both units. The City of Carefree even inspected and officially approved the construction of that slab in November 1998. So this piece of concrete had just been sitting there, quietly baking in the Arizona sun for roughly 9 whole years, before Ms. Strike even moved into her unit. Section 2. The conflict escalates. So if this slab had just been sitting there since 1998, why did everything suddenly blow up into a formal legal petition in 2013? Well, the catalyst wasn't the pouring of the concrete, but how it was being used years later. Sometime after Ms. Strike bought her unit, a new owner moved into Unit 604 next door. In June 2012, this new neighbor petitioned the HOA to enlarge that existing concrete slab. The HOA denied the request, basically telling the neighbor that the slab was in a common area, didn't actually belong to them, and absolutely couldn't be expanded. But the neighbor in 604 continued to place their private patio furniture out on that concrete, basically treating it like a personal deck. And this is what truly set Ms. Strike off. Now, you might be thinking the HOA just ignored the problem, right? Actually, no. Far from it. They generated a frantic paper trail trying to manage the whole situation. They sent formal violation letters to the owner of Unit 604 on November 1st, 2013, then again on January 7th, 2014, a third time on February 20th, and yet a fourth time on April 21st. They repeatedly asked the neighbor to move her patio furniture off the common area slab whenever she wasn't actively using it. But despite these repeated requests, the neighbor just didn't remove the furniture. Frustrated by what she saw as the HOA's complacency and total failure to enforce the rules, Ms. Strike took matters to the state level. Section 3. The legal arguments. This all brings us to May 6, 2014, and a formal administrative hearing. Both sides had to lay their legal cards on the table. Let's neutrally compare the core arguments they presented to the judge. Ms. Strike argued that the HOA violated state statutes by allowing the neighbor to construct and use the slab without proper consent from the affected owners. She believed the HOA essentially gave unauthorized approval and misled the neighbor. On the flip side, the Las Torres HOA mounted a multi-layered defense. First, they pointed out the area was a general common element, not a limited common element assigned to any specific unit, which meant some of the statute's strikes cited didn't even apply. But their absolute strongest procedural defense was jurisdictional. Ms. Strike was asking the department to force the removal of the concrete pad. The HOA argued this is a demand for injunctive relief, which the department legally lacks the jurisdiction to grant. Now, anticipating a glaring weakness in her case, which was that huge delay in filing, Ms. Strike offered a pretty fascinating defense. I mean, why wait until late 2013 to complain about a slab you noticed when you moved in back in 2007? Well, she testified that she was actually a member of the Las Torres Board of Directors until April 2013. She argued that she had signed a board member code of conduct that strictly prevented her from filing any unilateral legal action against the HOA while she was serving on the board.
Section 4, Arizona Property Laws and Standards.
To sort through this entire mess, Judge Douglas had to rely on some very specific legal frameworks. This wasn't about who was being a better neighbor. It was about what the law strictly dictated. First off, let's look at the standard of proof required. In this administrative hearing, the burden of proof fell entirely on the petitioner, Mrs. Strike, and the standard she had to meet was a preponderance of the evidence. In plain English, that just means she had to provide enough evidence to persuade the judge that her claims were more likely true than not. If she couldn't tip the scales past that 50% mark, her case would fail. Here are the three main Arizona revised statutes that really anchored the hearing. Ms. Strike relied heavily on the first two, Section 33-1218, which deals with allocating limited common elements, and Section 33-1221, which governs alterations and changing the appearance of common elements without written permission. But I really want you to keep your eyes on that third one down, Section 12-541, regarding liability created by statute. Because as we're about to see, this seemingly dry procedural rule is about to become the single most important factor in the entire case.
Section 5, the judge's verdict.
All right, the moment of truth. After reviewing all the timelines, listening to testimony from Ms. Strike, the HOA reps, and digging through the documentation, Judge M. Douglas was ready to rule. First, he established the undeniable physical facts. The current neighbor in Unit 604 absolutely did not install that concrete slab. It was installed by previous owners way back in 1998, and it was even inspected by the city. It was a well-established part of the property landscape when Ms. Strike purchased her unit in 2007. Plus, the HOA hadn't been entirely complacent. They had, in fact, repeatedly issued violation letters regarding that patio furniture. But, all those arguments about patio furniture, general versus limited common elements, and HOA board codes of conduct, they all ultimately took a back seat to this one single crucial number: 1. And here is the final legal blow. Remember ARS Section 12541? That statute mandates a strict one-year statute of limitations for liabilities created by statute. The judge ruled that the concrete slab was already in existence when Ms. Strike purchased her unit in 2007. She didn't file her petition until late 2013, roughly 6 whole years after she initially occupied the unit and became aware of the slab. Therefore, the judge officially declared, because Ms. Strike's petition was not filed within 1 year of the accrual of Ms. Strike's cause of action, it is time barred. Just like that, the entire case was dismissed and the Las Torres HOA was deemed the prevailing party. Just to officially wrap up the legal procedure, the administrative law judge's decision was transmitted up to the Department of Fire, Building, and Life Safety. The department had until June 20th, 2014 to accept, reject, or modify the decision. They took no action. So, on June 24, 2014, the decision dismissing Ms. Strike's case became formally certified as the final administrative decision by the department director. So, what should we take away from all of this? Well, this explainer perfectly illustrates that in the eyes of the law, timelines literally trump almost everything else. You can have a totally legitimate grievance about shared spaces, but if you sleep on your rights and let that statute of limitations expire, your arguments might never even get a chance to be heard. It really leaves us with a provocative question. Do you know exactly what is in your own HOA common areas? Who put it there? And maybe most importantly, how long it's been sitting there? Because as we've just seen in the world of property law, the clock is always ticking. Thanks for joining me on this explainer, and keep learning.